continuance until that jury trial can begin. I've already submitted a demand for jury trial.
I understand that, sir. What's your position on the case?
This courtroom session is running at full throttle, and what you're about to see is a rapid-fire look at how housing stability can swing in a matter of minutes. Right after this quick exchange between the judge and the first tenant, we dive into a case where someone has already taken an unusually bold step, demanding a jury trial in a landlord-tenant dispute. That move alone tells you the stakes are high, and this isn't a typical pay and stay or don't pay and go situation. Across today's docket, you'll watch the sharp contrast between tenants who show up and fight and those who miss their hearings entirely. Where missing a single call can mean losing your home instantly by default judgment. You'll see medical hardships, funding delays, car breakdowns, maternity complications, and real-life crises woven into the cold language of rent balances and court costs. As you watch, ask yourself, what would you do in these situations? Would you gamble on a jury, scramble for rental assistance, negotiate directly, or try to pay whatever you can just to buy time? This courtroom is where those decisions collide with legal reality, and sometimes pure urgency decides the outcome.
For an eviction. I've submitted a response to the complaint in writing. I have a copy of that if you'd like me to read it.
I have it. I'll set this case for a final settlement conference. What are my criminal dates? The 8th and the 11th we have. I'll set this final settlement conference for August 8th, 2025. That's at 9 a.m. That is in person. That's a jury final settlement conference. Jury selection in this matter will be August 11th, 2025 at 8:30. Both of those proceedings are in person. I'm going to require that the parties submit to the court written jury instructions. Those are to be filed by August 1st, 2025.
I think I have a copy of the written statement.
Did you send a copy to opposing counsel?
I sent a copy of the demand for jury trial to the opposing
counsel. Did you
counsel.
send your written answers to them?
I'm sorry.
You need to do that. You need to do that immediately. If you have a copy, you need to provide that to them today. Understood?
Yes, sir.
Right here, the judge gives us a mini masterclass in civil procedure. The tenant proudly says he submitted a response in writing, which sounds great, but when the judge asks, "Did you send your written answers to opposing counsel?" everything stops. This is a huge point many people miss. When you file something with the court, you usually have to serve the other side too. If the landlord's attorney doesn't get your response, they can argue they never saw your defenses or explanations, and that can seriously undermine your case at trial. The judge isn't yelling, but his message is crystal clear. You need to do that immediately. The tenant here actually gets a second chance. The judge doesn't throw his answers out. He tells him to provide a copy today. That's the difference between a judge who's just processing files and one who's trying, in the middle of a crowded docket, to keep the process fair. Here's a question for you. If someone can't afford a lawyer and doesn't know these rules, should their case really live or die based on a technical service error? Or should courts be doing more to guide self-represented people through the process?
Thank you. Court calls the case Hamilton Crossing versus Victoria Bolton.
Jillian Egan for plaintiff. She's not checked in.
Victoria Bolton, she's not here. You may proceed.
Thank you, Your Honor. This is a case for non-payment of rent. I have rent retained possession of $2,498. Court costs are $176 for a total of $2,674. Plaintiff pursued a default judgment for possession only with the writ to issue after.
Judgment to the plaintiff. That is by default for possession. Redemption amount is in the amount requested with the writ to issue 10 days. Court does call the case of Huron Vista versus Sabria, Williams.
Jillian Egan for plaintiff. Secretary for defendant.
Right. Where are we on this case?
Your Honor, we have a conditional order of dismissal proposed, and so I think we should be able to come to an agreement on it. If you would adjourn this to the 1st,
right.
we should have a COD to you by then. No objections.
That works? Okay. All right, I'll adjourn this matter to August 1st. Right there now. 2025 at
1 p.m.
1 p.m. Okay, thank you. Court does call the case of Huron Vista versus Takimo Reader.
Jillian Ingen for plaintiff. Not checking.
You may proceed.
Your Honor. This is a case for non-payment of rent. Rent to retain possession is $1,240. Court costs are $176 for a total of $1,416. Plaintiff is requesting a default judgment for possession only with a writ issue after 10 days.
Judgment to the plaintiff, that is by default for possession. Redemption amount is in the amount requested with a writ issue in 10 days. Court calls the case of Huron Vista versus Taylor Cole. Pardon?
She did not check in.
Cole, you may proceed.
Thank you, Your Honor. The case for non-payment of rent. Rent to retain possession is $2,104. Court costs are $176 for a total of $2,340. Plaintiff is requesting a default judgment for possession only with a writ to issue after 10 days.
Judgment to the plaintiff, that is by default for possession. Redemption amounts in the amount requested with the...
Did you notice how fast things moved once the court started calling those other cases? Tenant's name is called. No one appears. The landlord's lawyer reads out the balance. A couple thousand in rent, plus $176 in court costs. And within seconds, the judge grants a default judgment for possession with a writ to issue in about 10 days. That's it. Case over. A default judgment for possession means the landlord now has the legal right to take back the property. The writ is basically the court's order that allows an eviction to be carried out after the waiting period. These tenants may not have said a single word on the record, but they've just effectively lost their homes. Contrast that with the one matter where there's talk of a conditional order of dismissal. That's lawyer speak for, if the tenant does what we agree on, this case goes away instead of turning into an eviction on their record. One path is silence and instant loss. The other is negotiation and conditions. So, what do you think? Is it fair that missing a single hearing or failing to log in correctly on Zoom can cost you your housing? Or should there be extra safeguards before a default judgment in eviction court?
The writ to issue in 10 days. The court does call the case of New Park Ridge versus Alana Armstead. She does.
Yeah.
You think that might be... Could the individual whose phone ends in 835, can you hit *6 on your phone to unmute and tell us your name? I don't know who that is, but I have no response. You may proceed.
Thank you, Your Honor. This is a case for non-payment of rent. Rent to retain possession is $256. Court costs are $176 for a total of $432. Plaintiff wishes to take a default judgment for possession only with a writ to issue after 10 days.
Judgment to the plaintiff, that is by default for possession. Redemption amount is in the amount requested with a writ to issue in 10 days. No writ without a hearing.
Oh, I did not.
I'll put that up.
Thank you.
Case of New Park Ridge Apartments versus Karina Jones.
Jillian Ingen for.
Karina Jones, you need to unmute and turn on your camera.
Here.
Okay. Oh, there she is. Okay. All right. What's the claim in this case?
I have a total balance including court costs of $419.
Okay. All right. That's where we were last time. Miss Jones, how do you think you're going to get that paid?
I paid $200 this morning. And,
Okay. So you paid $200 this morning?
yes.
You don't have that. Okay. All right. So you'll be down at $219.
Okay, I was trying to see, could I pay the $219 by next week?
By
Friday.
next week?
Friday.
Friday the 25th?
Yes,
You think you can get it done then?
absolutely.
Okay, here's what I'll do. I'm going to adjourn your case out to August 1st, 2025 at 1 p.m. Okay?
Okay.
If you paid the 200 and you get the 219 paid by next Friday, the case is going to be dismissed. If you don't get all of that paid and you come back on August 1st, we're going to be dealing with August rent.
Okay, so it'll be paid. It'll definitely be paid on Friday, but
Okay, I believe you. I just have to.
In correction to the 419, I have 415.
415.
15, yeah.
All right, I just saved you $4.
okay.
Okay.
Thank you. I appreciate it. Every dollar counts.
All right, I do what I can. Okay. All right. All right, Ms. Jones, you get that paid. Okay, I probably won't see you again, so you take care of yourself.
Okay, you too. Thank you.
This interaction with Ms. Jones looks calm, even friendly, but the stakes are massive for her. The total balance is in the low 400s. She's already paid $200 that morning, bringing it down to around $219. The judge asks the key question, how are you going to get that paid? When she confidently says she can pay by next Friday, he essentially hands her a lifeline. He adjourns the case to August 1st and sets clear conditions. If the $219 is paid by the 25th, the case gets dismissed. No judgment for possession, no formal eviction record hanging over her. If she doesn't pay, the court will be dealing with August rent too, meaning the problem snowballs. Then comes that small but telling moment. She corrects the balance from $419 to $415, and the judge laughs. I just saved you $4. It's lighthearted, but it underscores how tight things are. Every dollar counts when you're this close to losing housing. For you watching, is this a success story of the system giving someone a fair shot, or a reminder of how thin the margin is between stability and eviction? And be honest, if you had a week to find $219, could you do it?
Provident Asset Management versus Sandra Moore.
Hello.
Hello, Miss Moore. How are you?
Good, how are you?
I'm doing well. All right, where are we on this case?
Well, I got a email between my landlord and Caitlin Oda. She just submitted it we're just waiting on approval.
Okay, hold on. You had some happy news, and so you were going to come up here and just start talking to me, right? So you got approved for funding?
I don't know. I'm waiting for approval. She submitted it, and she said she'll let us know when we get approved.
This is through HAWK?
HAWK, yes.
Amy?
That's what she said now.
And your worker's Caitlin?
Caitlin Orta.
All right.
Good afternoon, Your Honor. Let's see. Do I have Ms. Moore's permission to speak on this?
Can she tell me about it?
Yes, she can.
Yeah, okay, thanks. Yes.
I can confirm that Caitlin has been working with her in terms of the most up-to-date information Ms. Moore has provided to you. It appears that they're just waiting for the submitting of that amount is the first step, and the second step is waiting to hear back if it's they're going to basically have funds to take care of it.
Got it. Okay. So we have to wait for another answer. Nope. What?
Okay. It's been a long process. No.
You're not mad at me?
No.
Then I don't care.
Okay.
That's it. Okay, so if I put this over, what's your monthly rent?
$875
Okay. Are you going to be able
to pay August.
Yeah.
Yeah, we'll pay it. I'll pay it.
When can you get August paid, do you think?
Oh, I already, let's see. This is July, August. Around the 1st, that's when I've been paying.
Okay, so here's what I'm going to do.
I pay before the 5th because I don't want to pay late fees.
Got it. So I'm going to put this over to August 1st, 2025 at 1 p.m.
Okay.
Hopefully we can get an answer on that.
Okay.
But this amount will go up because you will have not paid the $875 by that point. you wouldn't have paid your August rent, so this amount will be different. But if they approve the funding, it may only be for the 2605
Okay,
or thereabouts, okay?
okay.
All right.
Oh, man.
Did that make sense to you?
It made sense. I'm just
Are you
for this to be.
see me?
No, it's not that.
No, I'm sensitive. Are you? Fine. Okay, that's fine. No, I'm not going to let you mess up my day.
Okay, all right.
All right.
Okay,
Okay, you take care. Have a
all right. you
weekend.
too.
This is one of the more human, almost sitcom-like moments in the docket. The judge teases Ms. Gardner for not having her baby on screen after 8 hearings, even joking that she's in trouble with the court's unofficial baby fan club. Everyone laughs, but underneath the jokes there's a real, thorny legal problem. Her lease on the current unit is ending in 2 weeks. She's already signed for a different unit in the same complex, but the manager is holding the keys hostage until they hear from the attorney and see proof of assistance in payments. From the tenant's point of view, that feels like unnecessary gatekeeping. From the property's point of view, they're afraid of messing up the paperwork. This is a possession case on the old unit, and they don't want to end up assessing rent or creating confusion on the new one while this is still unresolved. The judge tries to walk that tightrope. He notes the issue is about possession of the current unit, tells them to make a note, and vaguely suggests that showing the baby might help persuade people outside the courtroom. That's the reality. Law on the record, persuasion and personalities off the record. Would you, as a landlord or manager, let her move into a fresh unit while all this is still pending? Or would you wait until every agency confirms every dollar before handing over the keys?
Yeah. River Drive Apartments versus Ann Marquette.
Filling Egan for plaintiff.
Good afternoon, Your Honor.
Good afternoon. Your name?
Marquette.
Okay. And where are we on her?
I have a balance including court costs of $3,477.56.
All right. And how are we going to get this done?
All right. Well, first of all, I applied for an SER,
Yes.
and I've got the tracking number for that. Second of all, I applied for Jewish Family Services, and they are in the process of assisting me with that. Thirdly, I applied for senior housing through Washtenaw County. And although they told me they could not guarantee funding, I talked with the head of senior services, and she says the prospects look very, very good. They can come up with half of it. She asked me when I could come up with my other half, and I told her the 30th. She asked for a postponement for at least 2.5 weeks. What she's doing is she is going through central funding right now, which is a conglomerate of all the fundings in Washtenaw. And again, she is very, very convinced that I will qualify for that funding.
A lot.
Do what?
I said that was a lot. But no, I got you. So the 1,500 from the seniors.
Yes.
Okay.
Yes.
That's probably that one funding pot. I didn't know if they had a cap on it or not, but
No, they do. Well, they can't go over 3,000.
3,000.
That's their cap.
So how many people are in your unit?
I'm sorry?
How many people live with are in
One person,
you?
which is
So-
why they cap it at 1,500.
Right. And so your SER, if you were to get that, is basically $410.
Correct.
So that would be 2 of this amount. And then,
Right. And I get paid on the 30th. I get paid $2,000 on the 30th. The reason I fell behind is because my car at the middle towards the end of May, I had to put brakes, calipers, rotors, tie rods all the way around on my car.
what kind of car?
2010 Ford Fusion with over
A Ford had all those problems?
220,000 miles.
Oh, you driven it 220?
Yeah, I ride that baby. Let me tell you something, Your Honor.
Okay.
I am a Detroit girl who moved to Washtenaw.
You are?
I am.
Oh, you could have been going down. It could have been ugly. I mean, I'd fist bump you for it, but that could have
I
gotten
got
really
you.
bad.
I got you.
All right.
I got you. And the other thing that is a conundrum, right? It's a conundrum because I tried to work things out with River Drive Apartments, and I got a letter yesterday for me to make payment arrangements with them.
With who?
River
River
Drive
Drive?
Apartments. Can I submit these documents to you for the
Well,
court?
no.
No.
All right. So here's the thing. I believe you in terms of all of that. If you
Yeah,
got
yeah.
15 there and you got 2 that could come in on the, so how much can you pay on the 31st?
On the 2,
2,000? All right. And your monthly rent is how much?
1,078.
Okay. So here's what I'm going to do. I want you to pay the 2,000 by July 31st.
Okay.
Then what I'm going to do, and actually we may be in pretty good shape. I'm going to adjourn this to August 1st, 2025 at 1 p.m. All right.
Okay.
That should take us down. It's going to take us back up, but not all the way back up. It is still.
Here, with Ms. Moore, you really feel the emotional fatigue of navigating rental assistance. She mentions an email between her landlord and a worker named Caitlin. Applications have been submitted through HAWK, and now everything hinges on the dreaded phrase, "We're just waiting on approval." You can hear she wants to give the judge good news, but doesn't quite have it yet. The judge calls on the advocate to confirm where things stand. They explain that step 1 is submitting the amount owed, and step 2 is waiting to hear if funds are actually available. Legally, the judge decides to bump the case to August 1st, but he warns her, by then, unless she pays her regular rent of $875, the total amount owed will increase, and assistance might only cover the existing arrears, around $2,605, not the new month's rent. You also catch a glimpse of courtroom coping mechanisms. When she says, "It's been a long process," he half jokes, "You're not mad at me?" "Then I don't care," and then quickly reassures her he won't let her ruin his day. It's dark humor, but it keeps the mood from collapsing completely under the weight of stress and delay. Have you ever been stuck in that kind of bureaucratic limbo, where you've done everything right, but one email or approval stands between you and disaster?
We'll still be in good shape. Then we can hear the answers from all of the agencies as to whether or not they'll.
Okay.
Okay?
All right. Sounds good. Thank you, sir.
Thank you. You know, Lee, it is a good thing that you are a kind and gentle person because
I took the phone for you.
I know you took it for me. No, ma'am, you don't understand. That could have gotten ugly, but that's okay. We might have lost a Detroit girl. All right, but that's okay. Go ahead. I'm just saying that's just the way it works. But
I ain't no Detroit girl anymore. We might have lost a Washington girl.
Oh, no.
okay, well that happens. All right, all right. Take care. Court calls the case of River Drive versus Jason Pennington.
I had mentioned Detroit, didn't I?
Jillian Engen for plaintiff.
Good morning,
Your name, sir?
Jason Pennington.
All right, and where are we on this case?
I did talk to HAWK. I got denied because of what I make at Cinemark Theater.
Okay.
But I did go to, I have a group therapy, so I went to public aid office right there. And they gave me a case number because I was in jail from March 14th to the 21st. And my aunt and uncle had posted $5,000 bond on me to keep me out. So it took, being on home confinement, it took me longer to find work.
Okay.
And now I would get paid every 2 weeks from Cinemark, and I also get paid at Little Caesars too. I do have August's rent getting together. It's more of waiting on what public aid offices is going to do. But I'm still going to pay whatever I can pay every week.
Okay.
Until
So
we
let
meet.
me ask you this.
Yes.
How much can you pay, how much do you have in mowing at this point?
What's in my account right now is 94. I'm getting 300.
Hold on a second. What does plaintiff have as
I have a balance of two.
All right.
And, my case manager, they were able to get a check for $1,000.
Okay, so when is, they got a check for 1,000?
Correct, yes.
So when is that gonna be?
I believe they have it already. I haven't.
They just need to get it over to the landlord.
Yes, and I'm working on August's rent. I'm not gonna hide it. I'm not gonna dodge anything.
Okay, so here's what I'm gonna do.
Okay,
Tell your worker I want the $1,000 paid to the landlord by the 25th.
okay,
I'm going to adjourn your case over to August 1st, 2025 at 1 p.m. And let's see at that time, exactly where you are,
okay.
who answers, what assistance you're going to get, and see if we can get this wrapped.
Yeah, the reason why I have to keep this apart, because I also, in a home confinement, I also have a GPS tethering too.
Yes.
So that makes it more difficult to find a new place, you know?
Incarceration.
I don't want to ever want to see that place again.
I know. All
Once
right.
is enough.
Okay.
Thank you, Judge.
Court calls the case of Strong Future Homes versus Charles Ellison.
Everything, so I can show that to him. He's in it.
He is in Zoom on prompt.
No. Just say it, $1,000 check.
Charles Ellison.
This is a crack together.
Okay, there you
Okay,
go.
I'm trying to unmute my camera. Can you hear me?
Okay, hold on a second. All right, on the Charles Ellison matter. All right. How much is owing on this account?
I have a balance including court costs of $2,145.
All right. Mr. Ellison, how are you going to get that paid, sir?
I talked to Friends Indeed. They say they can do 500, and I talked to my worker at HAWK earlier this week, and they said that they just waiting on funds. And then my leasing office said that told me to ask you for a COD to get on a payment plan because I'm on disability right now. I only get paid once a month, so I'm pay it down like that.
Okay,
My client's willing to enter into a 6-month repayment plan.
you are. They are. Okay, so can we have that all wrapped up by the 1st then?
I think so.
All right. So, sir, what I'm going to do, they're going to propose a COD 6-month payment plan to you. They're going to put that in a conditional dismissal. So to give you guys time to get that done, for you to look it over and make sure everything's okay, I'm going to adjourn this out to August 1st, 2025 at 1 p.m. Okay?
Okay, thank you, sir.
All right. Thank you. Have a great weekend.
You too.
Court does call the case of The Haven versus Kiera Scott and Janelle Johnson. Hello.
Hello, Your Honor. How you doing?
I'm great.
That's good.
Your name?
Kiera Scott.
All right. And where are we on Miss Scott's case?
I have a balance including court costs of $4,816.58. It's my understanding that Ms. Scott has applied through HAWK, but they're waiting for the August 1st refreshment date, so they can't help at this time.
Okay. Anything you want to tell me?
Yes, Your Honor. December 23rd, I slipped and fell, and since then I've sustained 11 chronic injuries, and it's kind of like hampered me working. I've been living at the Haven for 6 years, but it's just been difficult because I have an injection coming up on August 8th that I still have to get in my back, but I'm getting them in my face, my neck, and my back, and combined with the medication, and I have proof. It's just been hard. Like she said, I applied to HAWK. I didn't know I could apply for a STR and HAWK at the same time. But
how many people are in your house?
Now it's just me and my daughter.
You and your daughter?
Yes.
Okay, so that would be about $520 if the SCR was approved. Okay, so how much is your monthly rent?
It's like 21, I believe 21.
2,100?
Yes, yeah.
Okay. So here's going to be our problem, and that is that that means you're gonna be in the neighborhood of almost 7,000 come August 1st.
I spoke with Kaylin. Well, they said they would cover the 3,000, and then I can have like the 1,300 by Monday, and then I just have to worry about
1,300 where now?
I have $1,300 that I can pay towards it by Monday.
By this Monday?
Yes, Your Honor.
Okay.
I'm trying. I don't.
No, I got you. I'm just trying to, I'm thinking because I'm just trying to figure out how to make the math work. Right? And
Your Honor, if
yeah,
it helps, I'm looking at, so at least as far as July rent goes, if SER approves and Ms. Scott pays the 1,300, we're going to be at 3,000 left on this balance. And so if HAWK covers that, then
right.
good through July.
The timing of their funding, which I said at one of the meetings we have, timing it at the first of the month makes no sense to me. But if everybody in the world would listen to me, we'd have a better place. But okay, let's do this. Okay. You pay the 1,300 by the 21st. Okay.
Okay.
Get that paid to the landlord. That's going to bring us down in the neighborhood of about what, 35, whatever. Are you going to have any additional funds you think you're going to come into?
Yes.
Now, outside of the help for your rent, but
Yeah. I was trying to borrow from my sister.
gotcha. Okay. So here's what I'm going to do. I'm going to issue a judgment for possession, finding no tribal issue. And the reason I'm doing that is I want to lock this figure in.
Okay.
Okay. And so if you pay the 13, you may have to come up with an additional 500 somewhere in there. Okay. And then that's going to put you right at about the 3,000. I realize we may kick into August, but we'll maybe at some other point, we'll try to figure that part out. But if I told you you had to come up with $500, soon do you think you can do that?
Well, can I have at least like a week and a half?
Pardon?
Can I have at least like a week and a half?
From today?
Yes, Your Honor.
Well, okay. I'll give you a little bit more time than that.
I appreciate it.
So I'm going to have her writ then issue August 8th. So what I'm trying to do is just seal the figure in that you got to pay to maintain your housing. This figure that I have doesn't include any of your August rent. Okay.
Yes, sir.
But let's try to see if we can get rid of that part and then do work from there.
Okay.
Fair enough?
Yes, I really appreciate it.
All right. Okay, thank you. Make sure to get the 1,300 into them on Monday.
Yes.
Okay?
Yes.
All right. Take care.
By the time we reach the end of this docket, a clear pattern has emerged. Legally, almost every case is about the same core issue: non-payment of rent leading to a case for possession. But the outcomes are wildly different. When tenants don't appear or don't unmute, the judge enters default judgment for possession with writs issuing after a short period. Those tenants are on a direct path to eviction. When tenants show up, explain their situations, and connect with agencies like HAWK, STR, or local nonprofits, the judge has room to adjourn, allow conditional dismissals, or build informal payment structures. Pay X by this date and we'll dismiss, or we'll lock in this figure now. And if you can raise a certain amount, you can keep your home. We see people dealing with medical injuries, maternity leave, disability, old cars, jail time, and home confinement. All real-world problems that the legal system translates into numbers. 875 here, 2,605 there, for 1,816 across 6 years. The judge tries to balance strict legal rights with practical mercy, but he never loses sight of the bottom line. If the money doesn't arrive, the landlord is entitled to possession.